stopping me particularly from going in and using it.
Yes.
You guys are denying me service because of my assistive devices.
That is correct.
Part 12 of a multi-part series featuring Guilford County, North Carolina. This is the final part of the 3-part pretrial evidentiary hearing. After court ended on March 2nd, 2022, Mike waited in limbo until finally being notified that court would reconvene to finish the hearing on March 15th, 2022. The whole hearing lasted nearly 9 hours, spread over 2 separate days, so we split it up into 3 parts. The following occurred on March 15th, 2022. Once again, there is a very long wait before the audio issues get worked out. To bypass this, skip to the 27.5-minute mark.
Are you able to hear me? I've tried that, and every time I do it, you can't hear me. Let me switch my audio. Yep, when I mute that, you can't hear me. Try one more time.
Yes. Thank you.
Judge.Klass, I'm ready.
They're trying to join.
Can anybody hear me in the courtroom?
I can.
Okay. If there's any, I can hear Mr. Simmons, but if there's anything else going on, I haven't been able to hear anything else.
Mr. Nelson, this is James.R.Capps. Can you hear me?
Yeah, I can hear you, Mr. Capps.
All right, there's nothing going on right now. We're still trying to get everybody logged on.
Okay, great. Thank you.
Yeah, I can hear you now. Can you hear me? Yes, can you hear me? That's all.
You need an extra power cord. I got an extra power cord.
Yes, I guess, I mean, you know. You got the internet. Now I'm ready to proceed.
Can you hear me?
I can.
Great. Your echo. Let me stop. So I have Ira on, and I think Ira is logged in under Christie and the Webex, just so the court's aware. And I believe, correct me if I'm wrong, Judge, I think we are defense's turn for evidence. Is that right?
That's correct.
Okay. May I know who the clerk is that we have in the courtroom?
Catherine Gaither and Ashley Coultraine.
Okay, thank you. Are the state's witnesses in the courtroom as well?
I don't see any witnesses in the courtroom.
Okay, thank you, Judge. Well, I would like to call Miss Gaither to the stand.
Who's in?
I would like to call Catherine Gaither to the stand.
Who's that? The clerk?
Yes, sir.
He's in training.
Okay, then the other, I think, was it Coultraine? Ashley?
So Capps has raised his camera, so I'm unable to see him. I'm looking at his ceiling.
Okay.
Judge has got his finger across his mouth, just kind of watching the screen.
Okay.
These are the answers you're about to give to the court are the truth, the whole truth, nothing but the truth, so help you God.
And I cannot hear the witness.
Just turn the mic.
I have no video for anybody else besides James.R.Capps and the judge and you and William.
Okay. And the interpreter says there's no video of the witness either. Can we get that?
Well, I don't know any way to do it. I can turn my computer.
Okay, he signed in under Ashley Coultraine. That's why. So now I don't have judge visual. I have witness visual.
Okay, that's fine. Ms. Coultraine, can you hear me?
Yeah.
And is there any way to get a microphone to her? I think I'm probably getting her audio from the judge's computer for somebody else's.
This is at least 4 to 5 feet away and a side view of her.
Can she have James's computer?
There's a sound, but it wasn't articulable. It wasn't.
Yeah, she's in the witness box. I can only see about her chin high, and she's about 4 to 5 feet away from the judge, the camera or laptop camera in front of the judge.
She said the defense table.
Yeah.
Can she maybe move to William?
Is there any way to get the witness by a microphone so I can hear?
I'm going to bring my computer over here and hopefully you can hear.
Okay, thank you.
She's out of view still. Just needs somebody to help adjust the video so she can be seen and heard. There, she's now standing in the witness box looking at the camera behind a glass partition.
Okay.
She has a mask on. but I do not have a visual of the judge.
Okay. Ms. Coultraine, can you hear me?
She's nodding yes and a thumbs up. I think they're waiting for you.
Ms. Coultraine, can you hear me? Can you tell me how long you've been working at the Guilford County Courthouse as a clerk?
About 8. I have been in High Point for 8 months. I think it's a while.
The audio is inarticulable. I can't understand what the response is.
I said I've been a clerk for about 8 years.
For about 8 years. Okay, thank you, ma'am. Do you have a copy or do you have the court file for this case?
The judge has.
Okay, can you reference that court file? Can you get it in front of you?
Yes, sir.
She's asking the judge to get it. He's handing it to you.
I'll just direct your attention to in the district court trial. There is a document filed, and it should be a 1-page. It's a medical document. It's from my medical records. It says something about a medical mask exemption. If you could just try to find that, please. And then just let us know when you have that.
I think she's speaking, but I can't hear.
I'm sorry, what was that? You have it? Great. So is that document a releasable as a public record as part of the case file?
I think she may have said something right.
Yeah, I didn't hear your response. Is that document releasable as part of the case file? I still didn't get the response. Is there any way we can get a better microphone?
Yeah, she has to walk back to her, kind of lean over 2 feet to the microphone, and she's waiting for your response now.
Okay. I just need the response from the witness. I couldn't hear the response. I think this would be all the questions I have for the witness. I just need to know if that document in the case file is releasable to the public as part of a public records request.
Came through static.
Yeah, it was still muffled, the response. Like, I'm not getting audio from the witness.
Can you hear me now?
Yes, I can. Thank you.
Yes.
Yes, it is. Okay, that's it. No further questions, Judge.
Okay,
Back on hand.
thanks, Captain.
Was there any cross-examination?
No question.
Okay, thank you. The next witness I wish to call is myself, Michael Nelson.
You raise your right hand and be affirmed.
Do you swear that the answers you have given to the court be the truth, the whole truth, and nothing but the truth, so help you God?
I so affirm. I would like to play a video for the court. And this video, Mr. Simmons, I believe, has, if you can share that video. It is the video that is referenced in the motion to suppress with the link. It's also the timestamps in the written motion correlates to this video.
Objection.
Okay, will you pause that for a second, Mr. Simmons? I just want to draw the court's attention. There will be two videos or two separate sources for the video in this. The top and the part that's already started to play is the video captured from the GoPro on February 4th, 2020, when I entered the public lobby of the health department. And then there's going to be the bottom video will be the video captured from my phone that was broadcasted live to YouTube. And that doesn't start until a few minutes in because the live was not running the entire time. You'll be able to see when the live actually begins from this video. There should be a clock running to show you actually how many minutes passed before the live was activated. So we can go ahead and start the video back, please.
How's it going? Hello? Talking to me? Talking to me? Hi, how are you?
All right.
I was here the other day asking about mental health. Who are you?
You need to leave.
I don't know who you are. I'm talking to this lady here.
You need to leave.
So
You have to do what I tell you. You need to leave.
okay, who are you?
Someone outside, I tell you.
No, I don't go with people that I don't know.
I don't talk to people I don't know.
Oh, okay. Then I'll talk to her.
But she don't need to talk to you. She don't want to talk to you.
Okay. Well,
What do you need?
I'm trying to figure out something about services here.
You've been here before.
Uh-huh.
You've asked the same question. All you do, you're harassing her now.
Excuse me?
You're harassing her now. You've been here before.
No, I'm
Asking
trying.
the same questions.
How do you know what question I'm asking?
Because I've heard you before.
What question am I asking?
Don't you know?
I know, but you're telling me. You're the one that's telling me that it's the same question, but
I say you've been here before. She's not answering the questions.
okay.
Do you have business here?
Yeah, I'm trying to conduct it. Who are you?
You don't need to know that. You just need.
Okay.
to conduct
Well, you
business
can't
and
give
leave.
people orders unless you identify yourself. So
Yes, I can.
okay. Well, your
You
orders
don't
are
work
invalid.
here. Well, we'll see.
Okay. Yeah, I'm just asking about the mental health. I was here the other day, and when right, I know I asked that last time, and they directed me to a building, and it was a private company. Is that the only mental health here?
I don't know mental health.
Okay, so this is the Department of Health for High Point or for Guilford? For High Point.
We don't know about mental health. They do their own
So
stuff.
you don't have that for.
They're not part of the health department.
Okay, no mental health at all for health department. All right. What about contraceptives?
You want the pack?
Can we, or do you just hand them out like condoms and stuff? Yeah, sure.
You gotta, we'll give you something, but that's all we got.
All right, cool.
We don't do nothing with mental health.
Yeah, I know they directed me there. I didn't know if it was part of the Department of Health because I got there and they said it was a private company.
It is.
And
They're not part of it.
Okay.
They've been gone for a while.
All right. Yeah, that's where I meant to come back and verify I went to the right place. You know, because I.
You did. Yeah, they're not part of it. They're not.
All right.
I'm getting kind of to you.
Okay. Okay.
Are you recording?
Hey, thank you. Who are you?
I'm your friend.
My friend. My friends don't just bark orders at me.
Well, sometimes you need orders like that.
No,
We
I
all
don't,
don't do the right thing.
I don't think anybody needs orders barked at them. You know.
Sometimes you have destructive people.
Uh-huh. Yeah, typically, my experience, they wear costumes and carry guns and...
Well, that's a costume you got on, didn't you?
What's that? I mean, I guess you can call any article of clothing a costume, but it doesn't really signify anything, you know? So, yeah. So you don't want to tell me who you are? Like, what? I don't know, man. I meet people everywhere. Yeah. That's why if I have a name, maybe it'll help me remember, you know? What's that?
Meet a lot of people you're not going to remember because you only see them in the flash. You're not going to remember their names. You might be better than me.
I might remember him
You're not filming.
if it's what's that? Film? Oh no, we don't use film anymore. What's that? I'm not sure actually. I don't know. Can you see if it's doing it?
I don't see anything on.
Yeah, I can't see if it's doing it either. So, you know what I mean?
I know.
Yeah.
I know. You can't see.
Yeah. So, you don't want to tell me who? You don't want to tell me who you are?
Where do you live? You live in High Point?
Well, I don't understand. Like,
You ask me a question, I'm answering your question.
You haven't answered my question. I've been answering yours question. Yeah, who are
What's
you?
your name? We know your name because they had it on the news the other day.
Oh, really?
You know, on YouTube.
Oh, yeah.
Yeah.
Okay. But what channel was that on? You want news channel?
You know, I don't know people confidence. You see this, you see that?
Uh-huh.
Like, oh, they said his name on there. I'm like, oh, okay.
Yeah.
Whatever, you know.
Okay.
I don't pay attention to that.
Some people think they know things and it doesn't mean it's real, you know?
This is true.
Yeah.
You taking a break today? We close in a little bit.
I know, close at what, 5? Yeah, all right. Yeah, I had to go bathroom, get some water, and check up on the. I thought the mental health was part of the Department of Health. They directed me.
It was about 4 years ago, and they split.
And they split. And they went private sector. Did you know if they just kept the same building and just a private company came in? Yeah. Yeah, because that's once they told me it was a private company, I was like, oh, okay. I thought that was part of the Department of Health. What's that?
You can't have people just kind of sitting around. I'm not talking to you.
Uh-huh. Oh, why is that?
Because you don't have official business here. You're taking care of it.
Oh, I do have official business here. No, I'm working on a news story.
A news story?
Yeah.
What kind of news story are you working
Well, identifying where the silver services are with the Department of Health, and you guys helped me verify that the mental health isn't part of that. And then,
You've been to social service.
but yeah, I went to social services, but I didn't get the whole rundown of everything. Some of the stuff is, what are you doing?
Turn to your camera.
Oh, why?
So you're not filming.
Oh, please don't touch my things.
Because that's against the law.
What is?
To film it without my permission.
Oh, actually, that's not true.
Yes, it is.
Do you know what law that is? What law is that? Your law. Well, who are you?
You need to leave.
It's actually illegal.
If you don't have business, you need to leave.
You touching my camera is actually illegal, sir.
It's illegal for you. No, I didn't damage it.
No, but you touched it without my
Your
permission.
camera, you can't see, right? So your camera's light is in my eyes, so
Oh, the light's on?
the light's on.
Oh, I'm sorry. Is that better?
Yeah, that's much better.
All right. So, you don't want to tell me who you are? Because you're like,
Why do you need to know?
well, you've been giving me orders or directives, and
You have to get out of here in a minute because we're
and then you just touched my property without my permission.
Well, your property was flashing in my face.
Was it?
Yeah, you didn't have permission to do that, did you?
To do what?
Flash it.
Is it still flashing?
It's not flashing now. But
Okay.
the light is in my face.
Yeah, I don't think it does that.
I don't know.
Yeah.
All I know is the light might have been from here. It was hitting my eyes.
Okay. Well, sorry.
And blinded.
Yeah, you could just ask me. You don't have to touch. You don't have to touch my things without my permission.
Well,
There's a legal term for that. It's called assault.
your question.
You know?
I can touch you.
And it's an extension of me. Yeah.
I can touch you.
It's an assistive device. So
You need to leave.
you're telling me to leave again?
Yeah.
Okay. Who are you?
Don't you see me?
No.
You're pretty good.
Yeah. Lots of training. Look at this cane. It's all beat up. It's all beat up. I changed out this ball sometimes once a month. This one I just changed out about a week ago, and it's probably going to need another change about another week. So lots of practice. But Department of Health here in High Point is an interesting story to cover, especially if I get some stranger ordering people around in the lobby.
Well, I'm not a stranger. You're a stranger. I work.
You work here. Okay. Well, if you work here, then aren't you supposed to identify to the public? Are you wearing a name tape or anything? You're not? Okay. I can't see it. Can you tell me what it says?
No.
You can't tell me what it says?
You don't have a need to know.
I absolutely do, sir. You actually touched my property without my permission, so that's a crime. If I want to report that crime, I need to know your name.
You were flashing that light in my face and that glare on that light.
Okay.
So I'm not gonna get into this with you, okay? We close in approximately 10
Will you at least tell me who you work for? Like, are you a sheriff's department
You
or?
need to leave in approximately 10 minutes.
Okay.
If you don't have business here, you need to leave.
So do you work for the sheriff's department or like High Point Police Department or like security guard company? Please tell me who you work for.
You don't need to know that.
Oh, I absolutely do. for a few reasons. One is part of the news story I'm working on, and two, you violated a few laws, and you're still kind of doing it right now.
No, I didn't. You violated the law.
What law is that? You said your law.
You were harassing the lady in here.
How is that, sir?
The lady told you she couldn't help you.
That was only because you interrupted and told me to leave.
Then you tried to force her to tell you something.
No, I did not. She could have absolutely refused. So,
She did.
somebody in there, there's a different voice. Somebody answered the question. Okay. How is force? What kind of force was I trying to use? They could have told me to kick rocks, and I would have gone to the next counter. Only because you were there trying to tell me to leave, and she believes you have some authority. So what authority does she think you have?
We close in 9 minutes.
All right. Thank you.
I know you're recording
Why is that?
because you got that thing, you got your camera turned.
Yeah, I use my camera for all kinds of things. My phone does amazing stuff. It's a great assistive device.
You glad this is good too. But you got 10 minutes, you got to run.
All right, appreciate that.
So we close.
All right, thanks. Well, again, I ask you to, what do you consider harassing?
You can't come in and harass, you were harassing her. She told you she didn't help you.
Oh, that's only because you interrupted and came in breathing down my neck telling me to leave. So she stopped the conversation because you interrupted and she thinks you have authority for some reason. Let me find this guy's got a supervisor because this is not cool. I'm running out of time here. Sir, are you still over here? Sir? Excuse me. Hi. Do you know where the gentleman was that was talking to me? Oh, thanks. Hi. No, do you have a supervisor I can talk to? No supervisor on? Okay. Do you know if there's a building manager or something? All right. Let me find somebody else that want to be helpful. Hi, are you still there? Do you know if there's like a building manager or a kind of supervisor that can come assist?
In Greensboro, probably, but we have a facilities person here.
Sure, like any kind of supervisory role, like administration, management, or something. Yeah, because can you tell me this gentleman's name? Like he grabbed my phone, like he tried to get my property, and he's not telling me who he is.
I guess she can, he can.
Okay, yeah, if you just get an admin person, that'd be great. Thanks. At the health department here in High Point. What's that? Oh, she said she's going to call somebody. So.
I'm sorry, who are you looking for?
An administrator or some kind of building manager.
Okay, well, I'm over the building.
Okay.
So I'm going to ask you one time to please stop recording right now.
Who are you?
It is posted on the doors. My name is Leslie.
Okay.
It's posted on the doors. There's no video recording. We have clients here that are here for medical reasons.
Yeah.
and you're violating their law, their rights.
What right is that?
They're HIPAA violations.
Oh, you know that HIPAA applies to the medical personnel, not to the public.
Okay, I'm not gonna debate with you.
That's cool. I don't want to debate.
Posted.
Can you tell me the name of the gentleman that is over here on my right? He grabbed my property.
This is our security, and this is our security. They're all our
Okay.
security.
Can you tell me the name, please?
I'm not going to, but you feel free to ask them.
Oh, I did. I asked him. He refused to identify himself after violating my my property.
Again,
Okay.
I've asked you to stop
Excuse me.
recording.
Okay, I need you to stop recording and you need
Who are
to
you?
turn that off.
Who are you?
Captain Darby,
Captain
Okay.
Darby?
you've been asked to turn the recording device off.
Captain Darby with what organization?
Guilford County Security,
Okay.
you've seen me before,
I haven't seen you.
okay? So I need you to turn the device off and stop recording, or
Okay.
you're gonna have to leave.
This gentleman assaulted me. He grabbed my property without my permission. So you grab. So he admits. So he admits grabbing it.
We'll take care of that later, but what I need you to do now.
Well,
I need you to turn
how do I
the-
file a complaint or a criminal report about that?
You can file that through Guilford County.
Okay. Is he? Are you his supervisor?
No, I'm not.
Okay. Can you identify him for me? Because I need a name to go with the complaint or the criminal
You can
complaint.
ask the officer, he'll identify himself.
Can you tell me your name, please? Okay. So somebody read me the gentleman's name.
You need to turn your recording device off, please.
Okay. I use these as
I've asked-
assistive
I
devices.
understand your
for
assistive devices, but
reasonable
you are
modification.
recording. If you don't turn your devices off, your recording device, not your assistive device,
These are assistive devices.
okay?
Sir.
If you don't turn your recording
Do you have
device
it?
off,
Is there an ADA coordinator, Miss Leslie?
you need
We
to
have
leave.
an ADA coordinator, not in this building, but you have been told to turn it off.
Okay. This is.
You
But
need-
this
you-
is.
You need to leave.
This is a
If you are
violation
not
of
going to
rights.
stop recording, you need to leave the building.
Okay.
Okay, I've asked you plenty.
Well, there was a crime committed, and I need to
Okay.
identify the person that violated that.
If
You know, that
you
committed
don't,
that crime.
if you
Does
don't
that make
leave
sense?
the building,
You're gonna be arrested.
You're gonna be
second degree
arrested.
trespassing right now.
okay?
So,
For
you're gonna leave.
second degree
Yes, now
trespass.
they're asking you to leave and you're not leaving the county building.
So that on second degree trespasses, if
Okay.
you're on the
Are
property
you
of
gonna
another.
leave?
I'm trying to clarify what's going on. So second degree trespasses, if you're on the property of another, and you're without permission, or you are asked to leave, or told to leave, and you refuse. Is that right? Is that my understanding of that right?
Whatever it is you want it to be.
Well, I just want to understand what you're threatening. Like if
I'm
you're
not threatening you.
Nobody's.
Are you gonna
threatening
leave, sir?
well, I'm trying to
Are
clarify.
you gonna leave? Yes or no?
You've been
Absolutely,
asked to
yes, I
leave.
will absolutely leave.
Let's go.
I'm just trying to
Because
clarify
now I'm about to
what's
put
going
cuffs
on.
you if you don't.
Wait a minute. So you are going to use violence against me? I'm trying to
It's
clarify.
not violence.
Like taking away my freedom is absolutely the violence.
Sir, are you gonna leave right now or not?
Yes, I'm trying to clarify.
go.
What do you mean by
Let's
secondary
go.
trespass?
Let's
Because
go.
it's
Well,
here,
5
we're
seconds,
gonna
I'm gonna tell you
clarify.
turn around, put your hands behind your back.
a property of another. That means it's, you
I
know,
go
this
down.
is, what are you doing? Whoa, stop. What are you doing? Who are you? Stop. Who are you?
You're
Stop.
being
Who
arrested.
are you? Stop. Who are you? Stop. Who are you? I don't know who you are. Stop. This is assault and battery. Stop.
This is
Help.
not
Help.
assault.
Help. Somebody help me. Stop. Stop. Ow. You're hurting me. Stop. Why are you doing this? Ah! What are you doing? What are you doing? What are you doing? Roll over now. Who are you?
Roll over.
Who are you? I don't know who you are. I'm breaking my arm.
Turn around, sir.
Who are you?
Roll over.
Who are you?
This is Officer Boyce, Coultraine Police Officer from North State. Now roll over.
Why couldn't you say that? Goodness. Why are you hurting me, man? Why are you hurting me? Boyce, North State, is that what you said? You say Boyce? You say Boyce, North State?
Roll over to your side.
Did you say Boyce with North State?
Roll over to your side.
You hurt me, man. I got all kinds of injuries, dude. Stop. Please stop.
Let's go.
Please stop.
Let's go, sir.
Please stop.
Sir, let's go.
Please stop.
You're already about 2 charges in. Let's go.
Please stop.
Sir, you can get up on your own, or I can carry you over. Let's go.
I'm pretty sure you hurt me. You injured me. So please stop.
Roll over.
Is there a disability coordinator, please? Can somebody get a disability coordinator?
Now we're playing the game.
Can somebody get a disability coordinator?
They got a wheelchair? Yeah. Let me get a wheelchair.
We get a disability coordinator, please. Somebody help! This man is attacking me. Somebody help me. Do you have a disability coordinator? Somebody? Anybody? Please help. I'm being assaulted and battered. Please help me. Please help. Somebody help. Help me. Somebody help me. Ah! Ow! Ow! Please stop. Oh, please help. Ow! Please somebody get a disability. Disability coordinator.
Get in the chair.
Somebody help me. Please stop. I've got foot injuries. Please stop. Please help. Somebody help me. Give me a disability coordinator, please.
Okay.
Ow.
Get him in the chair.
Ow. Somebody help.
Grab his arms. I'll get his legs.
Help me.
Set him up into the chair. All right.
Somebody help.
2, 3, up.
Ow. 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 Help. Somebody
Sit in the
somebody
chair.
help me. Help. I can't breathe. Put me on my neck. Help me. Ow. Ow.
Okay, sir.
Somebody help. Somebody help. Help me.
Okay.
Help me, please.
Take the bag off.
Somebody help. You get a disability coordinator.
Let me go get the big wheelchair.
Please. Somebody help me. Somebody help. Ow. 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 Stop. Please stop. Help me. Help me. Help. I can't. Stop. Please stop. Please stop. Please stop hurting me. Please stop. Please. Somebody get me a disability coordinator. Help. I'm being attacked. Please help. Ow. Help. Help me. Somebody please help me. Somebody help. Help. Ow. 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 Stop. Please stop. Please stop.
Get up, sir.
Please. Ow. 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 Please, ow. You're hurting me. You're hurting me. Why are you doing this? Please help. Somebody help. Ow. Help. Please help. Please help. Ow. Ow. Anybody hear me? Please help me. These men are hurting me. Please. Please help. Ow. Ow. Stop. Please help me. Somebody help. Please. Somebody help me. Ah.
Anything else gonna be probably sick.
Help me. Can we get a disability coordinator, please? Do you have one with your company voice? Disability coordinator. Please help me. Please stop taking my devices. Help. Somebody help. Boys, please get us help. Please
Somebody help. Please. I'm being attacked. Somebody help, please. You have a disability coordinator. Anybody? Leslie.
All right, sir. You're going in the wheelchair. Can't walk on your own power.
Please don't hurt me anymore. Please don't hurt me anymore. Please don't hurt me anymore. Please stop. Please stop. Please stop hurting me. Stop. Ow. 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 Ah. Why? Why are you hurting me? Why? Why are you doing this? Ow. Ow. Stop. I've got the injuries. Stop. Help! Help! Somebody help me! Help me! If you can see this, please record it. Help! I'm being attacked by people I don't know. Help! I'm being kidnapped! Help! Help! Help me! Help! I'm being kidnapped! Help! Somebody help! Help! Strangers have attacked me! Now they're kidnapping me! Help! Help! Somebody help! Please help! Anybody!
Copy.
Help!
He's got to lock these doors. He's got to lock these doors.
Help me!
This shit's still recorded.
Help! Hello! Help! I'm being kidnapped! Help me! Help! I've been attacked! Help me! Help me! You're kidnapping me! Help!
You got it.
Help! Help me! Help!
Joe, go ahead.
Hello, anybody? Kidnapping me! Help!
You got it.
Help! Help me! Help!
My bad.
Please help! Door! Please help! Disability coordinator.
Watch his head.
Disability coordinator.
What happens after this? I go see a magistrate and discuss his charges. Then the phone becomes bombarded with all his supporters. Sir, I'm gonna stop it here, Your Honor.
Any objection to that, Mr. Cole?
No objection.
Thank you.
What was that?
All right. While he's doing that, you want to go ahead and just come back in, and you can step down, sir.
No question. Or you
We'll
just wanna do
wait
that
for
tomorrow?
Mark.
All right.
Can you hear me, Judge?
Yes, I can hear you.
Okay, I'm going to proceed with testimony. That video that was just played. Again, there's actually several videos that I captured with both the body camera and my cell phone. The body camera was a static recording. I think it was actually the video that was played in court is actually a compilation of 3 videos, and there is this short body cam video of me entering and then going to the bathroom. At which point I stopped the recording, and then the recording picks up as I'm exiting the bathroom. That's the only edit to the videos because of privacy. I don't record when I go in the bathroom. Everything else in the video is a true and accurate representation of what happened on February 4th, 2020. So at this point, I would enter this video into evidence for the defense.
Go ahead.
Now, I guess I should cover the basics for testimony. The legal name I use is Michael Nelson. I am a disabled veteran. I have multiple disabilities from injuries sustained in my military service in the Army. My Army service was just shy of 11 years, a few months. And in the military, I started out as an infantryman and then went to Fort Bragg for Special Forces training or selection and training. And then I made it through the rigorous Special Forces training course and was awarded the coveted Green Beret. The specialty that I earned and focused in training was that of the Special Forces Medical Sergeant. The Special Forces Medical Sergeant training course is several years long, and it's the most prestigious or coveted training that they offer in the medical field in the United States military. There is no civilian equivalent to the scope of practice or the training that the U.S. Special Forces Medical Sergeants obtain and practice. And that's because the scope of practice is so broad. We do everything from pediatrics, geriatrics, veterinary work, dental surgery, all kinds of different surgeries, orthopedic, and we do hospital rotations throughout the country. A lot of rotations are in austere environments in Native American reserves. So I have been a qualified medical professional in my professional career, and one of the focuses or the I'd say the most time is focused on pre-hospital trauma with the medical course for the and on the ongoing training for the Special Forces Medical Sergeant. And that's basically my professional background. After I got out, I have been trying to focus on recovery, and I've been a contributor to news organizations, volunteering my time to share matters of public interest to be disseminated to the public, and focusing on equal access, equal rights for the disabled population. In the end of 2019, my family and I moved to North Carolina, and we didn't have a place to live. So we were trying to figure out what we could afford. And somebody told me that the foreclosure lists are kept at the county courthouses at the clerk's office, and that's the only place that they're kept in physical copy, and they're not published online anywhere. So the first encounter that I had with the Guilford County staff or state staff was December 18th, 2019. That was previously attested to by, I believe it was the two other state witnesses, the Alfonso Boyce and Vince Dougherty. They prevented me equal access to the courts on that date because of the use of my electronic devices that I use as assistive devices. And that began my investigation into Guilford County and the state of North Carolina in regards to compliance with the Americans with Disabilities Act. And we shared that information, or I shared that information with different independent media sources, and they disseminated that report or that story to the public. I continued that investigation over several months and visited several different Guilford County locations, including the health department that's adjacent to the Guilford County courthouse there in High Point, North Carolina. And I uncovered similar ADA violations, and I brought those to the attention of the people that were committing the violations, and also try to inform them of the proper process to follow the federal law and to make accommodations for the public. I followed up with ADA requests through disability coordinators and complaint processes. And it seemed like that was making progress. Again, was it 2 weeks ago when we first convened this hearing? There was a video we played from January 13th, I believe, January 13th, 2020. And that was my first visit to the High Point Public Health Department, or the Public Health. This is Guilford County Public Health Department in High Point. And that video that was played in court, contrary to the state's testimony, nobody told me to leave. One security guard, it was a Lieutenant Bowen, told me that I couldn't use my recording devices. But then actually Leslie Barbie was the one who made the accommodations in spite of that, and made it so that I could get services from the counter and get the information I was there to get. So that was a pretty benign encounter. It started off with the ADA violation of the security guard, Lieutenant Bowen, trying to tell me that I couldn't use the devices. Leslie Barbie stepped in and made sure that I could. A third person intervened, and I asked if that person was work there. He was telling me to turn off my video, and Lieutenant Bowen said that he did not work there. Well, after reviewing my videos and preparation for court, we found out that individual was security guard Calvin Robertson, and he was the security guard just featured in the video played in court. So from my first meeting, from the very first time I went into the health department, I was accosted by security trying to enforce a no recording device policy. But Miss Leslie Barbie actually helped me get the accommodations and get services. After I got the services, I left with no incident. Again, nobody told me to leave or threatened me with trespass. The second visit was on January 31st, 2020. That video was played again 2 weeks ago. It was played without audio because we couldn't get the audio to work. But in that encounter, we had security guard Vince Dougherty, and he again made accommodations. Nobody told me to stop recording. Nobody told me that I needed to leave. He actually directed me to the service desk or service counter. I asked the questions about mental health, and they gave me directions. Mr. Dougherty assisted me outside, and he gave me further directions so I can try to find this health department or the mental health department, mental health services. I followed his directions and found a location on the campus there, and found out that it was a private company, and asked if they were affiliated with the Guilford County Health Department, and they told me they weren't. So I wasn't sure at that point if I went to the wrong place, if there was a different facility that does do mental health services with the health department. So that was the reason for the revisit on February 4th, 2020, which is the date in question. So on that date, I had multiple purposes for being there. Like I just said, trying to follow up on if there is in fact mental health services the county provides, where it is, how do people get access to it. I was also there following up on the whistleblower investigation that I was doing. It's under the key TAM provision of the Federal False Claims Act, which simply means trying to make sure that the county is in compliance with federal law. And if they're not, then they're in violation of the Federal False Claims Act, because they swear every year to the federal government that they are in compliance with federal law in order to receive federal funding. So part of that investigation was making sure they were following ADA, the Americans with Disabilities Act, which is federal law, making sure that they were following Section 504 of the Rehabilitation Act of 1973, and making sure that they were following HIPAA, which pertains to medical personnel keeping medical information private and not allowing it to be released to the public. So that was the initial reason for being there. The reason for staying was the treatment that I was receiving from the unnamed individual at the time. Later, we found out his name was Calvin Robeson. As you saw and heard in the video, he refused to identify himself multiple times. Nobody would identify him. So the ongoing purposes was covering the story of the treatment in the health department, how the health department personnel treat a disabled member of the public. It was covering the ADA violations that were occurring, as they told me that I couldn't use my devices that are protected under the ADA. And it was to redress grievances. So it was the other part of the First Amendment, to make sure that I could redress my grievance about my treatment, that Mr. Robeson was bullying me, that he was mocking my disability, he was taking advantage of my disabilities, and then he accosted me, or I would say assaulted me, by grabbing my assistive device from my hand. And when he did so, if you want to look at that video again, he actually turns the camera towards other patrons, away from himself and towards other patrons. He lied about the reason for that. He said it was because there was a light, where the body cam video shows there is no light coming from the phone. So he kept giving me information that was blatantly false. And it was confusing on whether this person actually worked there, or if he was just somebody that was there harassing me and accosting me and then eventually assaulting me. After he continued to refuse to identify himself, I tried to find another employee to assist me so I can redress grievances about the treatment. And no employees would make that simple accommodation with just reading the man's name tag. And the video also shows that they never actually told me to leave, contrary to the state's witnesses' testimony. Leslie Barbie never once told me to leave. Dennis Dougherty never told me to leave, and he actually testified to that. He said that in his response that he in district court, he said it was always an ultimatum in his testimony, and in this hearing a few weeks ago, he said that it was always a contingent, that if I didn't stop using my devices, then he would ask me to leave. So he never actually told me to leave. No representative of the property that I identified themselves as representative of the property told me to leave the property. Alfonso Boyce didn't tell me to leave. He asked if I was going to, and I told him I absolutely would. I was trying to clarify my legal status with the property so that I could know if I can come back and conclude my business, because my business wasn't concluded. I still needed to file a complaint. I was trying to file a criminal complaint on Mr. Robeson, but I didn't have his information, and nobody would assist me with that. Leslie Barbie said that they're all the security. Said, this is my security, this is my security, they're all my security. There was nobody that indicated that there was a law enforcement officer present, even though I was asking about making a criminal report. Nobody identified themselves as a law enforcement officer until after Boyce attacked me and violently threw me to the ground. He choked me. And eventually, throughout this process, they rendered me unconscious and had me in custody for several hours. I still have nerve damage to both of my wrists, which cause numbness, and I lose my grip on things like my cane. When I'm walking around, I drop my cane way more frequently than I did prior to these injuries. The hospital that I woke up in, some 4 or 5 hours later, did a brain scan and found there was another brain injury, bleeding on my brain.
Object to the relevance at this point, Your Honor.
The relevance, Judge, the relevance is this shows
Your Honor, this is a motion to suppress the arrest.
The relevance, Judge, is this shows the implicit bias and malice of the state actors towards me if they're willing to inflict such bodily harm and disregard for the law. Then they were, of course, willing to give false testimony and do the initial attack in the first place. I didn't hear that response.
I'm a sustained objection.
Okay. Okay, I have another video to introduce. If Mr. Williams can get that ready.
While he's doing that, catch you up.
Yeah, please.
He listened to you about the gate.
You're ready.
Yeah, before you get it going, if you can pause it. If is it going yet? Okay. Can we pause the video, please? Mr. Simmons, will you pause the video, please? Okay, Judge, this video it should show the GoPro video that was just played on the left side. On the right side is the security camera video that the prosecution played in court 2 weeks ago. And I want to draw the court's attention to the lack of synchronicity. In the previous video that we just introduced, the videos were in sync, and that's how the videos look like and sound like when they are in sync. And in this video, this is evidence showing that the security camera footage has been altered and or tampered with. And so the footage from the security camera doesn't actually pick up into about the 9 minutes and 45-second mark. So in the interest of judicial economy, Judge, we can skip to that point where the security camera actually picks up. Excuse me, actually, can we back up to 9 minutes and 15 seconds? Do you have audio in the courtroom?
I don't have any audio.
All right, Mr. Simmons, you're gonna have to redo that so we get audio, please. But Judge, the relevance of this video, it shows that what the prosecution has entered is has been tampered with and altered the video evidence that he submitted 2 weeks ago, and this video is evidence of that. It's going to show the lack of synchronicity. Again, the very beginning, the security camera video is missing 9 minutes and 45 seconds thereabouts of video, and it misses the relevant portion of why I was in the health department in the first place. That I was there conducting business. That an unknown employee accosted me and harassed me and was mocking my disabilities. And interestingly, the security camera video doesn't actually start until after Mr. Robeson assaults me by grabbing my assistive device. It's about just under 30 seconds after that encounter is where the security camera video actually begins. Yeah, the audio is not necessary, Judge. This is for the pleasure of the court. If you want it, we can try to get it to work. It's really to show the disparity, the maliciousness of this prosecution, that this evidence has been altered with and tampered with, and the prosecution had foreknowledge of this. I have different timestamps, Judge. If you'd rather, we can go and show or we can play it from whenever the security camera footage starts and play it out to the end. But in the interest of judicial economy, we can do the timestamps, and we can show you how the same event visually happens in one video at one time, and in the other video, it starts out with a few minutes being off, and by the end of the video, it's off by over 4 minutes.
That's fine. You don't have to have audio.
Okay. Mr. Simmons, then we can just do it without audio.
Judge is leaning in and watching, hand on his mouth, fist on his chin, kind of resting and covering his mouth now. Capps is rocking back and forth. Reading the video. It's shared yet. Judge is looking at William, trying to see if we can get it started.
Christy, how much time do you have?
I'm off at the top of the hour, so another 32 minutes.
Okay, thank you. Hopefully we can get it done by then.
Yeah. I didn't see about permission if you need it.
Okay.
Go ahead and share it.
Mr. Williams, we have the video going.
He's talking.
Mr. Simmons, we're waiting on you to get the video to play, please.
Here we go.
Okay.
Yeah, if we can get it going at
12:09.
if we can get it at the 9-minute and 15-second mark, please.
You're not family. You are not.
Hi.
So you are not family.
Oh. Oh, please don't touch my things.
Well, that's against the law.
What is?
The family without my permission.
Oh, actually, that's not true. Do you know what law that is? What law is that? Your law. Who are you?
You need to leave.
It's actually illegal.
If you don't have business, you need to leave.
You touching my camera is actually illegal, sir.
It's illegal for you. No, I didn't damage you.
The video visual sync to draw your attention to is going to be at the 10:08 mark. There's a cleaning person that walks through the lobby.
Oh.
10 minutes and 8 seconds.
I'm sorry. Is that better?
Yeah, that's much better.
All right. So, you don't want to tell me who you are? Because you're like, you know,
Why do you need to?
well, you've been giving me orders or directives, and then you just touched my property without my permission.
Your property was flashing in my face.
Was it?
Yeah, you didn't have permission to do that, did you?
The next timestamp to draw your attention to is going to be at 10:45.
Is it still flashing?
I raise
Okay.
my cane.
Yeah, I don't think it does.
So you can, at 10:45, I raise my cane on the security camera footage, but that doesn't happen on the GoPro for another
There's a legal term for that. It's called assault. You know?
about 28 seconds.
That's an extension of me. Yeah. It's an assistive device, so.
You need to leave.
You're telling me to leave again?
Yep.
Okay, who are you?
Don't you see me?
No.
You can run pretty good.
Yeah, lots of training. Look at this cane. It's all beat up. It's all beat up. I changed out this ball sometimes once a month. This one I just changed out about a week ago, and
no longer
synced.
synced.
Another change.
The GoPro is 28 seconds behind. Okay, pause the video, please.
But you know, department and High Point is an interesting.
All right, so it starts off at the 10:08. Videos are synced, and just within a minute, the video is already 28 seconds off, meaning that the security camera footage occurrences happen sooner in that because that video has been edited and it has missing footage. We can go to timestamp 11:13, and you'll have Mr. Robeson starts walking towards the front. And the security.
Look at this cane. It's all beat up. It's all
Sorry,
beat up.
security.
Can
you pause that and go to 12:01?
I just changed out about.
So in the security camera footage at 12:01, Mr. Robeson starts walking away. That doesn't happen in the GoPro for another.
We close in approximately 10.
Will you at least tell me who you work for? Like, are you sheriff's department?
Another
or...
minute and 23 seconds later is when it happens in the GoPro. Okay. So you can skip ahead.
So do you work for the sheriff's department or like High Point Police Department?
13:20, like 13:22, and you'll see that same occurrence happen in the GoPro.
Or like security guard company. Only because you were there trying to tell me to leave, and she believes you have some authority. So what authority does she think you have?
We close in.
All right, so you can pause that.
Thank you.
The next visual is Officer Boyce coming in the front door, and that's going to be the timestamp for the security is going to be 15 minutes and 19 seconds. And you're going to see that in the security camera footage at the 15:19 mark where Boyce comes in the door. He doesn't actually come in on the body cam for over 2 minutes.
This guy's got a supervisor because this is not cool. We're running out of time here.
Okay. So you saw him come in. You can pause it and go to where it actually shows on the GoPro. It's at 17 minutes. 17 minutes and 20 seconds.
Capps is leaning back.
Posted on the doors. My name is Leslie.
Okay.
It's posted on the doors. There's
And that should show Boyce entering over 2 minutes after what it shows on the security camera footage. Pause the video, please.
Their law, their rights.
What right is that?
And we can keep going, but in the interest of judicial economy, we'll just go to the end and show the biggest disparity, Judge.
They're HIPAA violations.
Oh, you know that HIPAA.
Pause the video, please.
Personnel, not.
Okay, if you go to 22 minutes and 25 seconds.
To the public.
Okay.
And the visual you're looking for on the security camera
Is there
going to be where
please?
Where Boyce.
Somebody get a disability
Pause it, please.
Now we're playing the game.
Can somebody get a disability coordinator?
So at the 22-minute and 29-second mark, Alfonso Boyce is holding the body camera in his hand, and that's the visual that you're looking for in the security. And you can go ahead and play that. You back it up to before the 22-29 mark, please.
They got a wheelchair? Yeah. Get up on your own, or I can carry you over. Let's go.
I'm pretty sure you hurt me. You injured me. So please stop.
Over.
Is there a disability coordinator, please?
Okay, you can pause that.
Can somebody get a disability coordinator?
Now we're playing the game.
Can
Pause
somebody
video,
get a
please.
disability coordinator?
Okay, and the video doesn't actually show that on the GoPro. That doesn't occur for over 4 minutes and 3 seconds. So that time is going to be 26 minutes and 32 seconds. If you want to move to 26:32.
They got a wheelchair?
26:30.
Somebody help! Please! Somebody help me!
All right, you can pause or end the video there. So I would like to enter this video into evidence for the defense.
Objection. I made it.
This is evidence, again, as we just went through, that the security camera footage has been highly doctored with, has been highly edited. There's 9 minutes and 45 seconds before the security cam footage starts. It doesn't show my business in the health department conveniently for the prosecution. It doesn't show that I was accosted and harassed by the staff. And it picks up some 30 seconds after that at the 9-minute, 45 minutes. And then there's over 4 minutes of missing footage from the security camera video that the prosecution played as evidence. Let me think if there's any more testimony that I would like to give. Just give me a moment, please, Judge.
Oh, well. Take it down.
Okay. Yeah. In regards to the trespass charge, again, I was never told to leave. I was there conducting business. I was there to find out about services, specifically mental health services. I was there following up on an investigation under the key tam provision of the Federal False Claim Act, checking on compliance with federal law, such as the Americans with Disabilities Act, Section 504, and HIPAA. And I uncovered some violations with the first employee, Robeson, accosting me and telling me things that were not worthy of belief, and accusing me of trying to force my way on the staff to answer questions, and belittling me and mocking me because of my disabilities. So then I was there to redress grievances for that behavior, and I needed the individual's information, his identity, so I could make those complaints and redress of grievances. For the resist charge, again, the officer didn't tell me that he was a police officer before attacking me. In fact, the director or administrator, Leslie Barbie, said that they were all security. So as far as I know, the only people that I was engaging with was Miss Barbie, who was administrator and security, and not police, nobody with arrest powers. And I was still trying to clarify the legal status with the property and make sure everybody understood what they were doing was not valid under the law. And so for the RDO, after being attacked and slammed to the ground multiple times, because of the history of my injuries, previous brain injuries, and my I have C-spine injuries as well, and injuries to my my knees. As a medical professional, like, step one is to not move somebody with a suspected C-spine or brain injury or head injury. And so I knew that from my medical experience in the military, and it was not safe for me to move because I just sustained another injury. I asked for help. You can hear it on the video over 100 times, and no help was rendered. Nobody rendered any kind of medical assistance. And as far as we know, that didn't happen all the way through custody. They dumped my unconscious body outside. The EMTs found me an hour after that occurred. So I believe that's all of the testimony I think I want to give on direct.
Any cross-examination?
Just a couple questions, Judge. Mr. Nelson, this is James with the DA's office. Can you hear me?
I can, Mr. Capps.
You testified that you were at the health department working on a news story, a whistleblower claim under the key tam provision. Is that correct?
Yes, sir. Key tam provision of the Federal False Claim Act.
What does that mean?
Which part?
Well, just describe what you were there doing. I'm just trying to get an understanding of what you say you mean by that. You were there working as a whistleblower claim under the key tam provision.
Sure. The Federal False Claim Act has a provision called the key tam provision, and it allows anybody to conduct an investigation, and then you can submit that your findings to the federal government, to the Department of Justice Civil Rights Division, and the DOJ then will review your investigation and find out if it has merit, and if they want to pursue charges against any body that is in violation of the key tam provision of the Federal False Claim Act. So in this case, I've uncovered several instances where Guilford County had violated federal law, specifically the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, by discriminating against me. And I was continuing that investigation because you have several years to compile that information before you submit it to the DOJ for their consideration and for them to actually take legal action.
What happens after the DOJ takes legal action?
That process, there's different ways that they handle that. They can either assign a special prosecutor, federal prosecutor, to prosecute the case. In this case, it would be Guilford County that they would prosecute. And they can also prosecute in tandem with the investigator, or the term is relator or whistleblower, as the more common vernacular. The provision actually calls a whistleblower a relator. So in that case, I'd be acting as the whistleblower / relator. So the federal prosecutor would contact me, and they would either decide, hey, we're going to prosecute this ourselves as the U.S. government, or we can ask you to co-prosecute. And in that case, I could have the opportunity to have an attorney assist me with the prosecution of the claim.
And you were at the Guilford County Health Department February 4th, 2020, correct?
Yes.
And according to their testimony, Mr. Barbie asked you to leave or stop recording, and Mr. Daugherty asked you to leave or stop recording, correct?
No.
Well, so you were not asked to leave or stop recording.
Is that a question?
That's a question, yes, sir.
Yeah, can you restate the question, please?
So is it your testimony that you were not asked to leave or stop recording?
Yes, that is correct. They asked me, and Dougherty actually testified that he told me to stop recording, and if I refused to stop recording, then he'd ask me to leave. That's different than saying you need to leave or stop recording. That's
And
reverse.
you were placed under arrest, correct?
Say that again.
You were placed under arrest, correct?
I believe I was unlawfully kidnapped.
It's a yes or no question, Mr. Nelson. You were placed under arrest by Officer Boyce, correct?
Are you calling for a legal conclusion?
I'm just asking you a yes or no question.
I did not hear Officer Boyce say that he was a police officer. I didn't hear him say that I was under arrest. I was, as far as I knew, I was being attacked by an unknown person and then being kidnapped.
So is your testimony that you were not placed under arrest?
No, I didn't say that.
So is your testimony that you were placed under arrest?
I didn't say that either.
Are you refusing to answer the question?
No, I'm not. What do you mean by placed under arrest?
I'm asking you if you were arrested February 4th, 2020 by Officer Boyce at the health department.
I believe that's what the Officer Boyce claimed, but it was a kidnapping.
I don't have any other questions, Judge.
Yeah, I guess just the redirect would be just kind of following up on that last question and answer. Again, Mr. Boyce never told me he was a police officer. He never tried to effect an arrest in a reasonable manner, of the way a reasonable officer would, with somebody with multiple injuries, including visual impairment. You can effect an arrest just verbally. There's no need for any kind of force to effect an arrest, and that was not the option that was chosen. Instead, I was violently attacked and slammed to the ground and injured further, and then taken against my will. So that's why the answer is what it is. I have nothing for redirect, and I don't think I have any more evidence, Judge.
Anything else?
From the defense, just argument.
You may proceed.
Okay. Let me get my notes. Actually, can we take a couple minute break, Judge, before I can get my notes set up?
We'll do that. We'll take a 10-minute break.
Thank you. Yeah. All right, Christy, this will give us a chance.
Everybody back.
I am back, Judge, for the defense. I also have an interpreter ready to go.
Whenever you're ready.
Thank you, sir. In the written motion to suppress, we have I made several arguments, and I'm going to take them one at a time with my oral. And Judge, I tried to send in a copy of the different case laws that I'll be referencing. Hopefully you have those.
I have those.
Great. So starting off, I think the first and foremost, this case is about the Americans with Disabilities Act, and the codification in North Carolina is North Carolina General Statute 168A. It's the state's non-discrimination act based on disability. It doesn't quite have all the beefiness that the Americans with Disability Act has, but it's North Carolina's attempt to have some kind of state codification into that. The Seminole Court case is the Supreme Court case of Tennessee v. Lane in 2004. That revolves around an individual, Lane, where he was going to court and he was wheelchair bound, and the courthouse was not accessible. They didn't have any ramps or elevators, and the court was going to be in a courtroom on the second floor. And the bailiffs told him he had to make it in there somehow. So he got out of his wheelchair and climbed up 2 flights of stairs on his hands, so he can attend court. And he climbed back down 2 flights of stairs on his hands. And then when he came back to court, the second appearance he had, they told him the same thing. And after being humiliated and demeaned and discriminated against, he decided to stand his grounds on his rights, and did not climb up the stairs again on his hands. And he had some consequences from the court for that. And he took that all the way to the U.S. Supreme Court. And in 2004, the Supreme Court found that a violation of Title II of the ADA is a violation of the 14th Amendment and the protections thereof, specifically the Due Process Clause. That's primarily at play here in this case. Again, this is what triggered my investigation into Guilford County, was the violations actually entering the courthouse, trying to get public records. The state's witnesses in this case testified that they recognized my devices as assistive devices. The video from December 18th confirms that. The video and all of the videos that were played in court show that I always argue that these devices that they are saying is recording devices are, in fact, my assistive devices. These are the same devices that I've used in several court hearings, including this court hearing. And the state's witnesses testified that the direction to leave was always contingent upon me stopping using those devices. If I did not stop using those devices, then they'd ask me to leave. And that is akin to telling somebody in a wheelchair that if you don't get out of your wheelchair, we're going to tell you to leave. That's clear discrimination under the ADA. It's a clear violation of NCGS 168A, and it's a violation of my human rights protected by at least the 14th Amendment.
Judge appears to be making notes.
Again, the superior courts in North Carolina, both here in Guilford and in Rockingham County, have recognized these devices as assistive devices and have made the accommodations for me to use them in court. As soon as the government agents told me to stop using my devices in the health department on February 4th, they...
You can wait 1 minute. The court reporter needed to get something.
Oh, sure.
Judge is currently resting his face on his hand and he's speaking to someone off camera.
We ready to proceed, Judge?
I don't think so quite yet.
Okay.
I'll let you know.
Thank you.
He's looking off to the side Now he's reviewing something in front of him. Testing his glasses. Resting his head on his, rubbing his eyes. Reviewing notes again. Looking off to the side. Pressing his chin on his hand. Took off his glasses, sitting back, rubbing his eyes. Resting his head on his head on his hand now, waiting, sitting back.
Judge, I can't seem to connect back to the digital app. So if you don't mind, if I stand up a little bit and listen through your computer, I can record that.
That's fine. I'll turn it mine up. That's no problem. I'll turn mine up. See if it's here. Just tell me when you're ready. Okay. You may proceed.
Okay, can you hear me clearly, Judge?
Yes.
Thank you, sir. Let me draw your attention to, I believe I sent in, it's 42 USC 12203. That's the section of the Title II of the Americans with Disabilities Act that says that it's illegal for an entity to use coercion, threats, intimidation, or to interfere with a qualified person with a disability in receiving goods and services in equal access. As soon as the county employees told me that I could not use my devices, and then backed that up with threats of trespass by telling me that they'd ask me to leave if I did not use or stop using my assistive devices, that triggers that protection of the ADA, which is also a protection of the 14th Amendment. The Americans with Disabilities Act was written in 1990. It was written on the back of, or the foundation of the Rehabilitation Act of 1973, specifically Section 504. And it's been amended, I believe, in 2008. And the language is as broad when it comes to assistive devices and assistive technologies. The ADA intentionally, and Congress intentionally, did not specifically make a list of approved devices. And that, I believe, was in the wisdom of Congress because of the nature for technology to advance, and especially at an exponential rate like we're currently witnessing around the planet. The accommodation that we are currently using with the Webex, where we're having video conferencing, face-to-face court over the internet, was something of science fiction when I was growing up. It was something on TV in Star Trek that people thought would be hundreds of years in the future that would be able to have this kind of technology available to us. Well, technology is advancing rapidly. The realm of assistive technology is equally advancing rapidly. Wearable technology is all over. different devices that assist people with different disabilities is incredible and ever changing. And I'm on the cusp of that. I'm on the tip of the spear, so to speak, when it comes to assistive technology with the visually impaired community. So I am best qualified to help somebody understand what is and isn't an assistive device for somebody with visual impairment. Sadly, the typically state-run entities and county-run entities have very little to no training in the Americans with Disabilities Act. They're supposed to have disability coordinators, in fact, 2 per site that has 15 employees or more. And then through my investigation, I found that's not the case. But I asked to talk to them regardless. I asked multiple times in the encounter on February 4th to talk to them. And for that reason, to help facilitate equal access, because I understand there's a lack of understanding, a lack of training of what constitutes assistive technology. They refused that request, which is also another violation of the ADA and violates the protections of the 14th Amendment. The ADA says that anybody can grant the request, but in order to do a denial, it has to go through a department head, it has to be put in writing, and they have to specifically state how granting the request would fundamentally alter the goods or services. That did not happen on February 4th. It was a blanket denial, which is a direct violation of the ADA and violates my rights protected by the 14th Amendment. To the defense that I was told to leave. I was never told to leave. The direction to leave was always an ultimatum, was always contingent upon me giving up my rights protected by the 14th Amendment and the First Amendment, which I'll get to the First Amendment argument. The video with Robeson telling me to leave, he never identified himself, so that authority of the property was never triggered. So you can't count Robeson's direction as being binding for me to leave the property. He never said that he was a security guard, never identified himself as being an authorized person to tell somebody to leave. As far as Leslie Barbie goes, she testified here in this suppression hearing that she told me to leave, but she also testified that she told me to leave 2 other times prior. And the videos that we played refute that testimony. It actually impeaches her testimony. It's also contradictory to what she gave in district court, where she agreed with the testimony of Vince Dougherty that the direction to leave was always an ultimatum, was always contingent on me stop using my devices. That's not the testimony she gave in this hearing, and the videos show that that's just patently false and not worthy of belief. So Miss Barbie didn't tell me to leave. Then we go to Vince Dougherty. And Mr. Dougherty has stayed true with his testimony both in district court and in the suppression hearing, and it actually is frankly the only testimony on this subject that's worthy of belief for the state's witnesses, where he affirmed what the video confirms, and that the direction to leave was always contingent upon me and the devices. If I didn't stop using the devices, then I'd be asked to leave. And so I'm thankful for Mr. Dougherty's testimony in that matter. It's pretty clear that the evidence supports that. Now we go to the last person that may have had authority to tell me to leave, and that would have been Alfonso Boyce. Again, Alfonso Boyce never identified himself, so it's the same thing as Robeson, that authority was never triggered, that he never told me to leave. He asked me if I was going to, and I told him absolutely yes, I was. I needed to clarify my legal status with the property. I was concerned with making sure everybody was upholding the law and upholding my rights, and I still had to redress my grievances. In fact, Mr. Boyce was trying to solicit a trespass. You can hear in the video played today that, and in his body cam video played 2 weeks ago, that he told Dougherty to tell me to leave. His intention was try to harm me. And that is blatantly evident by the body cam video that was released and played in court 2 weeks ago, pursuant to your order, Judge, to Brady. And that was the video Mr. Boyce's body cam recorded on January 31st, 2020. It's very telling. It's very exculpatory, and it shows his premeditated thought process, his intent to do me harm. He went around trying to solicit a trespass that day from county staff, unsuccessfully, and it showed he was upset that I left the property. He said, "Come back, you bastard." He wanted me back. He said, "I can't throw you to the ground now. I can't put you in handcuffs, and I can't arrest you." And that's exactly what he did just a few days later at the health department. He actually enacted what he was premeditated, like what that video shows was premeditated act. But he never told me to leave. And he had no probable cause to believe that I was trespassing. A reasonable officer in his position would know that nobody had told me to leave. And what they were doing was a violation of my civil rights. Going to the implied consent argument, the case there is State v. Mark.E.Klass. In the Mark.E.Klass case, this was about people. It was on quasi-public property, and they were protesting something with the business in their public lobby. And since the business was open for business in the public lobby, they had an implied consent to be in the business. The court said that the public has implied consent to be on public property and quasi-public property, and that consent can only be revoked if the person does something that raises to the level of a disruptance or disturbance to the business. It has to go to a high enough threshold. Of course, a crime would be meeting that threshold, but the lowest standard is to disrupt the business. And in the February 4th, there was no. I did not disrupt the business. The evidence bears that out. There's testimony in district court and in the suppression hearing from Vince Dougherty that says that my demeanor was calm, collected. The video supports that I was trying to conduct business all the way up until the time that they attacked me. So my implied consent was never revoked, and a reasonable officer would know that I still had consent to be in the building because I didn't do anything that would revoke that consent. And if they tried to trespass me, even if I was told, arguendo, if they did tell me to leave, my implied consent was still intact. So their trespass would be unfounded and would not be supported by the law. And that's, again, State v. Mark.E.Klass. The state's position on this in district court is what he argued in district court was that people in the lobby of the health department, the public lobby of the health department, have an expectation of privacy. And the courts all across the country, including the U.S. Supreme Court, disagree. People have no expectation of privacy in public. The Guilford County Security has a security camera in the lobby. They record in that public lobby. It's subject to public records. We received the video from public records requests. The policy that they have is an attempt to thwart people's rights to be able to cover matters of public interest and disseminate it, protected under the First Amendment. Anybody can record people coming and going just outside the building. As Leslie Barbary testified, that the front face is glass. The doors are all glass. People can do video recording outside the building, and so that's can be recorded from public, whether it be inside the lobby or outside the lobby. It makes no difference. Again, there's a security camera run by the county that's subject to public records as well. The argument that Leslie made on the scene that it's a violation of people's rights under HIPAA isn't worthy of belief, and she actually testified to that. I think that's the only part of her testimony that is worthy of belief, is the section on HIPAA where she said that HIPAA applies to the medical professionals. It doesn't apply to the public. If for some reason medical information is released to the public and it's heard or seen by somebody in the public lobby, it's not the public's fault. They can't be charged for violating HIPAA. It's the health employees that can be sued under HIPAA for violations. The testimony that we got today from the clerk of court falls under that same line, and that case is the Vermonti v. Presbyterian Health Services. And in that case, it's a North Carolina case that came about due to a malpractice suit, and a doctor brought in medical records and introduced them into evidence. And after he introduced them into evidence, the court ordered the file to be sealed, and then the media filed suit saying this is a violation of the First Amendment and that the courts are to be public and open. and it was a violation of General Statute 7A-276.1 that was the order was to be voided from the court. That order to seal the records was to be voided. That was upheld, or actually, excuse me, it was the court ruled in favor of the media and said that reversed the court's order to seal the record and to release the medical records that were filed in the court file as a public record. The court ruled that even though medical records are private in nature and should be protected by the medical staff, as soon as they enter the public domain, like in a public courtroom that's open to the public, then they no longer have that protections under HIPAA because they're open to the public and the public has access to it. Just like in this case, as the clerk testified, my medical record of my medical mass exemption is in the public record and it's subject to public records request and disclosure. In the same way, anybody walking into the public health department in the public lobby that happens to overhear or see anything that would be private medical information in nature is now in the public domain because of a violation of the health department medical staff and not on a violation of the public. Going to the First Amendment defense, again, we established that I'm a journalist and I've contributed to public consumption of relevant public information. The case I want to draw your attention to, Judge, is Hutchins v. KQED. It's a Supreme Court case from 1978, and that case, I believe, is in California. I believe it was a sheriff. It was whoever the custodial law enforcement agency was. They wanted to do some PR for the public and give the public access to behind the scenes jail and what the jail was like beyond just what the normal visitors can see. And they let the public come in to do tours and see the facilities and see how the inmates were being treated. And the TV news reporters wanted to have that same access. So they showed up with their TV news cameras, and the security and the sheriff's department said, "Oh, no, you can't have your cameras here." And so that's what this case is about. It went all the way to the U.S. Supreme Court in 1978. And the Supreme Court found that anywhere that the government opens its doors to the public, they open its doors to the press. And so they actually said, no, the press has a right to be there with their video cameras to record anything that they can see and document anything they can document, just as the public has a right to go in and walk through. And it makes perfect logical sense. Like if you're going to open it up for that intention for the public to see it, not everybody has the chance to go to the jail and tour it. Not everybody has a chance to go find out what services are available in the health department. That's the beauty of media. It disseminates information to a wider audience and gets information to people that they need to have access to. The whole idea that the founders had for the First Amendment, at least the freedom of the press clause, is that it's vital to the genius of a free country for the people to be able to hold the government accountable, for the people to be able to document what the government is doing with the people's money, to make sure that they are following the law, that they are following their oaths, that they aren't violating the rights of the people, and that the services are what the people want to be provided and what they're paying for. Now that initially looked like pamphlets and leaflets like Benjamin Franklin made on his own printing press and handed out to the people. And in the 21st century, that looks like social media. That looks like live streaming to YouTube. That's our modern day equivalent of pamphlets and leafleting. Anybody can start a channel. Anybody can disseminate information to the public, and that's protected under the First Amendment. The 44 years of jurisprudence on this has been confirmed by circuit courts all over the country. And just recently in 2021, in the Fourth Circuit, it's the Dyer v. Smith case that you have, Judge. Now, the prosecution argued in district court, and he may argue or try to argue a case from 2020. I believe it's a Benzing case. And that's prior to this ruling coming from the 2021. So in the prosecution's case, it's a year before. And in that, the Fourth Circuit actually doesn't settle the matter. They said they actually abstained from deciding whether or not the First Amendment protections extend to the public's right to record public officials in the course of their duty. They basically didn't come down either way on that. And the Benson case from 2020 that the prosecutor has. In the 2021 case of Dyer v. Smith, the Fourth Circuit finally acquiesced, and they ruled alongside of their colleagues from the other circuits that affirms that the First Amendment protections apply to the public's right and ability to record public officials in the course of their duties. And that's simply what happened on February 4th, 2020. The health department is open to the public at the time in question and time and date. It was open to the public. The video bears that out. The testimony bears that out. The public has implied consent to be there, and therefore the press has implied consent to be there. Now, there's retaliation issue at play as well, and the case on that is Suarez v. McGraw, and the Fourth Circuit found that a violation of somebody's First Amendment protected rights, retaliation because somebody's exercising First Amendment protected rights is a violation of the First Amendment itself. That's definitely obvious here in this situation. Again, the premeditated intent as seen in the body camera from January 31st, the testimony from Mr. Boyce, the beginning of his body camera on February 4th, where he said, this fucking clown, he said these people, and on the stand, he said that he's talking about First Amendment auditors. This shows you his mentality, his disdain for the First Amendment and those that exercise their rights protected by the First Amendment. So we have a First Amendment retaliation issue at play. Leslie Barbie said that they did preparation for me to come back to the health department. That was testimony that she gave. She also testified that she received phone calls and emails and things afterwards. So her testimony is clearly biased because of the people redressing their grievances under the First Amendment. The retaliation was not just simply because I was broadcasting. It wasn't simply because I was reporting a story and exposing the way that they're violating federal law. It was also a retaliation for me trying to redress grievances. I was trying to identify the man who accosted me, who assaulted me by grabbing my assistive device. And all he said was he was an employee. He never said what position. He never said his name. And nobody would confirm that for me. And if they would have, that would have been the end of that encounter. I would have taken that information and followed up with criminal complaint and with a complaint with the county. But they didn't give me that information. We have since followed up with those complaints, but it took a while to identify the individual.
Judge is leaning back, resting head and chin. His hand.
So in summary, Judge, I had every right to be in the public health department in February 4, 2020. I was there for the reasons already stated. I was conducting an investigation into ADA compliance and compliance with federal law, such as HIPAA, as part of an ongoing investigation under the key tam provision of the Federal False Claim Act. I was there as a journalist reporting those conditions and what services were available because I wasn't sure if they had mental health services or not. And that visit actually confirmed that they did not. Was extra important at that time because the mental health services at the Department of Veterans Affairs was shutting down due to COVID in 2020. And so knowing what services were available for the public was, I would say, a great interest to the public in that time. I was met with hostility, with somebody mocking me and my disability in the form of Mr. Robeson, who didn't identify himself. Nobody made the accommodation to simply read the man's name, which is further discrimination, and prevented me from redressing my grievances. Another thing to note, Judge, is the focus that the security guards put on stopping the recording devices. So again, that violates the First Amendment. They tried to stop it as best they could, and eventually, I think the phone died from the battery dying. Because they don't know how to operate it because it's not set up. And you probably saw in the video, it's set up so it's not used visually. It's used auditorily with my headset, like I'm currently using it for my notes. So the violations we have for the Constitution here are the First and 14th Amendments, freedom of the press, and the clause to petition the government for redress of grievances. For the 14th Amendment, it's protected with the ADA, according to the Lane Court in Tennessee v. Lane, 2004. So just as the court suppress evidence that is gathered subsequent to a Fourth Amendment violation and an officer violating somebody's Fourth Amendment rights, I'm moving that the court suppress evidence of the trespass charge subsequent to the violations of the First and 14th Amendment violations. And that was triggered as soon as the staff ordered me to turn off my devices and then started to threaten me with trespass if I did not. So everything subsequent to being ordered to turn off my devices protected by the ADA should be suppressed, and following the jurisprudence on suppression law in the state. Now we go to the resist, delay, obstruct charge. In regards to resist, delay, obstruct, if the trespass charge falls, then the resist, delay, obstruct charge falls because it's fruit of the poisonous tree. If since Boyce didn't have probable cause to enact an arrest for trespass, a reasonable officer would have known that he didn't have the elements of trespass, would have known that you can't tell somebody to get out of their wheelchair, and if they don't, we're going to trespass you. They know that it's just the same. You can't do a news story in here, or we're going to trespass you, right? A reasonable officer would know that. Therefore, he didn't have probable cause to enact a trespass arrest. And since he didn't have probable cause for that, the subsequent charge of resisting a public officer must also fall. But if that doesn't convince the court, Mr. Boyce did not identify himself as a police officer. I would say he never identified himself as a police officer, even though he verbally said he was after attacking me, after trying to enact his arrest. I asked him some 9 times to identify himself, and he already had slammed me to the ground and put me in an arm bar before he finally said he was Officer Boyce with North State Company Police. And I argue that that's not identifying himself as a police officer. Just like if a plainclothes officer tells somebody to do something or not do something and has no visible form of identification. There's no badge, there's no gun, there's no uniform, there's no marked car. It's not worthy of belief for somebody to walk up to you and say, yeah, I'm a cop, you need to do what I say. That's not identifying yourself as a police officer. And since I cannot see whether he was or was not in uniform, he offered no way for me to verify he was a police officer at any point. So I would say at no point did Mr. Boyce identify himself as a police officer. He tried to verbally, but I was not able to confirm that was the case. So as far as I knew, I was dealing with security guards, as Ms. Leslie testified, as the video confirms, and was being attacked by people who did not have the power of arrest. So that goes to the second element of RDO. It says that the person must have reasonable knowledge to believe that the officer is a public officer. Clearly, that's not the case here. That charge has no legs whatsoever. There is no probable cause that I knew he was a public officer at any point. The cases on that, you have Bartley v. High Point, and then there's a juvenile case. It's NRETTE. In the Bartley case, Mr. Bartley was an elderly man in High Point, and a plainclothes officer approached him on his driveway. He had an unmarked car. Mr. Bartley said he didn't see the lights on the car, and that he didn't have any visual information confirming this person was an officer. The officer gave him different orders, and Mr. Bartley ignored them because he didn't think this person was a police officer. The officer grabbed him from behind, slammed him on the car, and was charged with the same charge of resist, delay, obstruct. That charge was dropped, and Mr. Bartley sued the city of High Point for violations of his rights, for excessive force and Fourth Amendment violations. In the juvenile case, in RETTE, the juvenile was at school. There was a resource officer. There's an incident the officer wanted to investigate, and he came up behind the student and told him to stop. The student didn't stop, and he grabbed the student, and the student, responded with resistance, and then was charged with resisted lay obstruct. The court found that he was not guilty of resisted lay obstruct because the officer did not properly identify himself. Everybody's blind from behind, and so these cases are on point for this current case, where again Mr. Boyce did not identify himself to a visually impaired person.
Still resting his head in his hand.
Hold on, excuse me. Okay, resisted lay obstruct must be more than mere remonstration, and that citation is State v. Humphreys. That's a 2020 case. In the State v. Humphrey case, the court found that you can't be found guilty of resisted lay obstruct for simply remonstrating with an officer. After Boyce verbally tried to identify, I gave him the benefit of the doubt. I knew that if I tried to resist, I would likely sustain more injuries, whether he was a police officer or not. And believing that I had sustained injuries during his attack from my medical experience, I did not offer any kind of resistance and simply remonstrated, was simply asking for help. I asked for help over 100 times. No help was rendered. No medical assistance was rendered. And simply remonstrating cannot be deemed enough to charge somebody with resisted lay obstruct. For the element of willfulness for resisted lay obstruct, I believe it's the last element. Again, the citation is State v. Humphreys, 2020. And that states that in order to satisfy the element of willfulness, the defendant has to be purposefully and deliberately violating the law. And that's exactly what the court said in State v. Humphreys. That's clearly not at play here. The video bears that out. It shows that at every step of the way, I was the only person concerned with the law. I was the only person making sure everybody was trying to follow the different laws at play. And you heard Robeson say, me recording was against a law, and I asked what law. He said his law. You heard the threat of second-degree trespass, and I tried to clarify what that was so everybody understood that that's not at play. And the officer Boyce said that it is whatever I want it to be. So again, that doesn't give any confidence that that person is a law enforcement officer if they can't confirm what secondary trespass is. Again, he never said he was at that point. And then the last citation is State v. Mobley, and that says that it is lawful for people in North Carolina to resist an unlawful arrest. So if Mr. Boyce was trying to enact an arrest, it was definitely unlawful. I had every right to resist, and there's no probable cause to think that that it was anything other than an attack by somebody who didn't identify himself. So for those reasons, Judge, there's sufficient evidence that you've heard through testimony and through video evidence that shows that my rights protected by the First and 14th and Fourth Amendment have been flagrantly violated, and subsequent to those violations, all the evidence gathered after that should be suppressed.
Thank you. Anything for you? Thank
They're just leaning forward.
Mr. Nelson, can you hear me? This is James.R.Capps.
I can, Mr. Cap. Thank you.
And you're on my approach. Judge, I've handed you a couple cases that I'll reference just to answer the three questions that are posed in this motion to suppress. They deal with the First Amendment Mr. Nelson raises, this issue that he raises, as well as the trespass issue. The state's contention is that there's three questions to answer here. Is there a First Amendment issue that authorizes him or grants him the ability to take his phones or cameras or devices that he has for the purposes of recording inside a public building, specifically on February 4th, 2020 at the health department? The second question is whether there's a trespass. Again, that's answered through the cases that reference that, mainly with the implied consent issue. And then the third question, if there's no First Amendment issue, if there's no trespass, is it a lawful arrest effectuated by Officer Boyce? Briefly, on the First Amendment issue, I've handed Your Honor two cases. That is the Benzig case, as well as Hodge, the County Board of Commissioners. These are federal cases. The Benzig comes out of the Western District of North Carolina. That's a June 2020 case. This will draw the court's attention to pages 6 and 7. The important holdings by the court in that case is that it does note that there is no absolute First Amendment right to record public officials doing their duty. Specifically in the context of this case, it's talking about recording in government buildings. The court goes on to reason that courts have previously upheld restrictions concerning the use of cell phones in government buildings, where it cites the Hodge case. It cites that the courthouse's own policy, indicating that the restriction for the possession and usage of cell phones in the courthouse, and the court also indicates that generally these restrictions are viewpoint neutral and generally applicable because they don't limit a defendant's right to speak, and they're reasonable in terms of the purposes that those policies serve before. In the Hodge case, just draw the court's attention to some holdings on page 3, where it indicates that there is no First Amendment right to communication that guarantees a right to carry a cell phone in a government building, because cell phones can be used to photograph and or record closed or sensitive proceedings for unlawful purposes. Prohibitions of cell phones in the courts and public buildings is a common precaution. The inconvenience or discomfort to individuals based on security measures do not rise to the level of constitutional violations. I would submit to the court that that's what this policy is over at the health department. It's not an unreasonable policy. Again, I believe when we had our first hearing on March 1st, a couple weeks ago, there was a policy indicated on the door. And again, realizing that Mr. Nelson is visually impaired and does not read the signs when he goes in, but the court took judicial notice of the sign on the door, and underneath that sign, it said something to the effect of no recording devices allowed without express permission. Just draw the court's attention, there's been no evidence submitted whatsoever that Mr. Nelson did have express permission to carry his devices into the health department and use them to record. And that's exactly what he did. He's admitted that he did that. His evidence that he put on shows that he did that. He told the court in the video that we watched today, the first video, you saw 2 video frames. The first one on top is the one that he said was from his GoPro that was recording before he entered the health department and continued to record. The one on the bottom was from the cell phone that live streamed the video on YouTube. So he went into the health department recording that encounter in violation of the policy. In violation of the policy that courts have reviewed and have stated that there is no constitutional violation. And again, without any evidence whatsoever to suggest that he had any express permission to do that in the health department. Draw the court's attention just briefly to some notes from a previous video that was showed the last time. I believe that Mr. Nelson showed a video from January 13th on March 1st, where he was interacting with Lieutenant Bowen with Guilford County Security. Lieutenant Bowen told him that it was okay to bring a cell phone to communicate or navigate, and then explained to him that he could not record in the lobby of the health department, but if he had an appointment with a healthcare provider, at that point he could record that if his healthcare provider consented to that recordation of that appointment with the doctor. So again, nothing to suggest that on February 4th, Mr. Nelson came into the health department with any express permission to record. Again, we know why he was there. He admitted to the court why he was there. He was there to record what was going on. And just briefly, before I move on to the trespass issue, addressing the reasonableness of the policy, I think it's worth pointing out to the court and the court considering before you make your deliberation on this, the reasonableness of the policy. Mr. Nelson contends that there is no expectation of privacy. There's no difference in expectation of privacy from someone walking from the commons area into the health department building. However, the state disagrees with his interpretation or his view on that. Again, Ms. Barbie told you that there are people that go in there to receive services who are children, who are juveniles. There are people that go in there to receive services that are victims of sexual assault. There are victims of crime in there to receive healthcare services. There are folks in there who are there for sensitive matters. And again, they do have an expectation of privacy once they walk through that door where it's posted that you cannot record in here. This is different, recording in here from recording outside. There is an expectation of privacy that they have once they walk through that door, that they can go in there with some sort of degree of anonymity if that's what they're choosing to do. And again, that's what the policy is in place for. That's what Ms. Barbie articulated to the court. The policy is reasonable. There is no First Amendment issue here. So because there's no First Amendment issue, moving on to the trespass issue. The issue is whether or not his implied consent to be in that public building is revoked. Once he goes in there recording with his GoPro and with his live streaming camera. Draw the court's attention to just a couple of cases, State v. Nickens and State v. Hunt, specifically State v. Hunt. That was a case from Asheville. That was an incident where a law enforcement officer was working security for a restaurant in his off-duty capacity. In that capacity, he still maintained the power to arrest if he needed to. There was an incident where an individual came and approached the restaurant multiple times. He was told to leave. He continued to come back 3 or 4 times. And eventually he was trespassed. Now, he was trespassed on the sidewalk. Again, I understand the issues there with the sidewalk being public, but he was trespassed on the sidewalk, placed under arrest, and then engaged in a struggle with the law enforcement officers. He was ultimately charged and convicted of RDO, assault on a government official. In all candor to the court, the jury did acquit him of the second-degree trespass charge. However, the court did find in that case that the officer had PC to arrest him for trespass because he kept coming back after being told to leave, after he had come to the restaurant for a community making scene. I recognize initially there was no belligerent scene, there was no disturbing scene. Mr. Nelson was not initially causing a disturbance when he was in the healthcare building on February 4th. However, it did escalate to that point the longer he decided to stay in there and engage with Mr. Robertson, Ms. Barbie, Captain Daugherty, and Officer Boyd. Based on the case law that the court has, one's implied consent to be in a public building is revoked. After the implied consent would be removed in the cases that Mr. Nelson cited in the Mark.E.Klass case. In that case, the implied consent was revoked after that individual started a disturbance. In the cases that Your Honor has before you, and then the State v. Hahn case doesn't really address the implied consent. It's more the PC to arrest for the trespass. However, the State v. Nickens case, that individual was trespassed out of a DMV building. The DMV would be a public building after creating a scene, after they wouldn't give her her driver's license back because she wanted to wear a hat in the picture. DMV employee told her that she could not keep a hat on in the picture. So she began to get belligerent with them and eventually engaged in a struggle with some of the DMV security workers. Again, here, the reasons that Mr. Nelson's implied consent was revoked. Again, no evidence to suggest that he had any express permission to be in there recording on February 4th. After he's previously been to county buildings and previously been put on notice or told that he cannot record in these buildings, he goes in there, he's recording on 2 different devices. Miss Barbie testified to you that she watched it before she engaged with him that day. Officer Boyce told you that he brought up the YouTube live stream before he engaged with him that day. So they are aware that he is recording once they encounter him. Again, because he's previously been put on notice that he can't do that, the state argues that that's all we need at this point to revoke his implied consent. He's told you need to stop or you need to leave. He's told that multiple times. He's told that by Officer Robertson, by Captain Doherty. Mr. Nelson argued that he was never told to leave, that it was always contingent. However, he was told multiple times by multiple people that if you do not stop recording, you need to leave the property. At that point, after being told by the 3rd person, Officer Boyce effectuates an arrest for second-degree trespass. Based on his testimony, based on his body cam, based on Mr. Nelson's video, he's present when he's been told to leave or stop recording. He's not witnessing leave. In fact, Mr. Boyce tries to engage him about leaving, and then Mr. Nelson wants to argue with him about what second-degree trespass means. At no point does Mr. Nelson ever take any initiative or ever give any indication that he's going to willingly leave on his own. Again, having his implied consent revoked due to the conduct that day for being in the health department recording without any express permission or without any authority to do so. The state would contend that Officer Boyce did, in fact, make a lawful arrest for second-degree trespass. After he made the arrest for second-degree trespass, the state would contend that Mr. Nelson, at that point, when Mr. Nelson winds up on the floor, based on the counters on the videos, there's probably a good 5 or 10 minutes where they're trying to get him up in a wheelchair and get him out of the health department and over to the magistrate's office. That's 10 or 15 minutes. Again, you can hear there's a scene being made while that's happening. Again, while this is still being live streamed on YouTube, mind the court. So Mr. Nelson is continuing to resist until he gets to the courthouse. So having answered those questions, arguably, the state would contend in the court that there's no First Amendment issue. He was in fact trespassed. Officer Boyce did observe him being trespassed, and he did trespass him himself. He was trespassed by 3 people with the authority to do so. And then after he was trespassed, he continued to resist by causing a struggle there in front of the pharmacy area of the health department. So based on those reasons, I'd ask the court to deny the motion. The state would contend there's no merit to the motion. Ask the court to deny the motion, but I'll respect the court's ruling.
What I'm gonna do is I'm gonna reserve to have a chance to look at these cases, and I'll let y'all know something this afternoon. Thank you.
Okay, may I have a chance to do a rebuttal argument, Judge?
Mm-hmm.
Yeah, Mr. Capps said that I had caused a disruption at some point. That's just not. There's no evidence of that at all. The video and the body cam, the testimony, all says that my demeanor was cordial and calm throughout. I was trying to redress grievances at the end, and I only elevated my response after being attacked. And so that's the disturbance was actually caused by the staff and not by myself. Again, the Benzing case that he cites was from 2020. The Dyer v. Smith case that I give you, Your Honor, is from 2021. And the Fourth Circuit actually finally agrees with its cohorts and the other circuits, saying that the First Amendment protection does extend to the public recording public officials during the course of their duties. So that Benzing case is old, even though it's from 2020. The Fourth Circuit actually came and finalized that in 2021 in the Dyer v. Smith case. The prosecution doesn't make any argument on the 14th Amendment or on the Americans with Disabilities Act. Completely silent on that act, on that behalf. And that's the crux of this matter. Again, the assistive devices that I used that day, I'm using currently as we speak. I've used in several court cases. And the court restricts access and use of technology far more than the health department does. And in the health department, the policy that he's citing from the sign, it doesn't say no recording. It says no recording devices. Like we got on the testimony, they were enforcing that selectively. They've only enforced it upon me as far as we can tell. The video shows that several people walked through with their phones in their hand. Somebody had it in their pocket, in their chest pocket. It's visible from the security camera footage. They didn't enforce the no recording policy or no recording device policy on them. It was only enforced upon me as a retaliation for the First Amendment, for publishing stories exposing the way that the county has been violating the ADA and potentially how they were violating HIPAA. Again, the standard for review for the First Amendment is whether or not it's a public forum. And for the analysis that I've understood, the health department there is a limited public forum, which means that they have to meet a reasonableness standard, and the prosecution cannot meet that reasonableness standard. And again, I cite Dyer v. Smith that found that the people have a right to record even a pat down or a strip search of somebody at the TSA airport. And that's way more invasive and way more private situation than simply somebody checking in with the health department. The health department, they don't treat patients in the public lobby. There's no treatment going on. If there is treatment going on, if there is disclosure of private health information, it's a violation of HIPAA on the health department and not on the public for overhearing it. And that's basically my rebuttal, Judge. Thank you.
I'll let y'all know as soon as I have a chance.
All right. Thank you, sir.
Stay tuned for more. Thanks for watching. Deo presso, liber.